Yeah, after 5.5 years or so on my case, Carlos Garcia, he has failed to attack the legal significance of my case. He's concealed, you know what I'm saying, what he's required by law to reveal.
Right.
And even himself created, participated in creating the preservation, preserving the evidence that he knows that is false. He should know that the evidence is false against me.
Right.
So he's worked against it the whole time. And so, after filing a complaint, the state bar, you know, against this fraud that he committed against me that I talked about previously. He stopped my federal lawsuit from making it, you know, to the defendants that I filed it against in the city, and I got proof that he did that. And after, you know, constantly disagreeing with me or not even, you know what I'm saying, present evidence to my case, considering evidence of my case, and creating an atmosphere where it's unprofessional, and he tried to use his skills as a lawyer to make me look dumb or like I don't know what's going on. But since I've been here, I've got law books. I studied law for the 5-6 years I get here, so I became aware of the things that he should be doing.
Right.
And once that happens, they still want to look at you as ignorant. But the Court of Appeals don't look at, they say ignorance is no excuse to the law. So I want my rights protected. I'm fighting for my rights, and I want him off my case because he continued to create smoke screens instead of doing his legal duty. He's court appointed. He hasn't evidence in my case like DNA, fingerprint evidence has not been tested. We don't have an investigator to investigate this case. So now, the COVID put us behind. It's been an off year. And so the whole time, the DA, Fred Burns, had no problem with my lawyer prolonging the case as far as like creating these unfounded claims to get the case continued. That frustrated me because I was telling them that he has to litigate my case, and he hasn't been doing that.
Right.
He's filing defective motions, and I told him that these motions have to be relitigated. And he's not, like I've explained before, he's not. The police officers are witnesses in my case. When they subpoena, they aren't showing up.
Sure.
He's not saying that, so that's cited on the record. He never challenged that the police officer that got this search warrant lied, and he did so with a reckless disregard for the truth. He never pointed out that no one said I sold any drugs in the whole affidavit. He never said that the police officer rubber stamped this search warrant because it doesn't say nowhere that I committed a crime, despite what they said in the public. I got the affidavit and I was able to look under the laws and understand that it has to be facts concerning a criminal activity at the place where the police officer is requesting a search, and the judge has to be able to determine from the affidavit from the police officer that there's fact of crime being committed at this household. Other than that, the Fourth Amendment draws a fine line at the home of the door, and it says that as long as the party's not at play, the sheriffs can't come running and knocking on the door and kicking the door in.
Right.
So he failed to point this out in the affidavit. Instead, he pointed out an argument that's been denied millions and millions, thousands of times in the Court of Appeal, claiming that the judge had no probable cause to issue a search warrant. The
Crazy.
judge don't have to have probable cause to issue no no search warrant. So I asked him, why would you raise that issue? So that's one. That's number one. That's number two. As far as the police witnesses not showing up on lawful issue affidavit, he's filing false affidavits. Number three, he's not investigating the case, the DNA, the fingerprint evidence. These police officers took evidence home. So that's the grounds for suppression of evidence, but he's trying to put everything in one motion and not being specific about none of it. And the appellate court says this: when you file motions, you have to be specific about the claims that you're making, and they are not required to search the record to look for your complaint. So this is what happens to so many people when they get their rights violated and they try to talk about stuff that the lawyer said. The appellate court said, no, it's not our job to look on the record. And so therefore your issue is waived. He has to file a motion and make your claims on that motion. So I understand the legal significance. That's the legal significance. And so I know my rights, and I want my rights protected.
Right.
And so we just had a hearing on the 7th. And so here's some more unethical things that this lawyer's been involved in. Okay, I was able to obtain through people looking on this Facebook page and listening to your Facebook page that you set up, and I thank you very much for that. And so the gun club was able to contact a lawyer, and somehow this organization, I don't know where it's at, but I know one of the lawyers is out of D.C. and the other lawyer is here in Dallas, named Justin Moore. And so what happened was they were able to obtain funding for me to hire I think 2 or 3 attorneys. And so now that they talked to this attorney, Carlos Garcia, and told him to start the process of getting off my withdrawal from my case because of the fact that I not have legal counsel. What he did, instead of doing the ethical thing and filing that motion, he did the unethical thing and told my lawyer that he has to file a motion to substitute counsel. And my opinion of that is that's not proper.
Right.
That's unethical for you basically resisting to get off my case, and I have to have paid counsel. So what he did by my lawyer filing that motion, and I wish he wouldn't have filed that motion, and because of the fact is now we had the hearing on the 7th, and so the prosecutor wasn't complaining when my lawyer's creating all these smoke screens, not doing his job, because him and my lawyers are huddled up together. I actually seen him get his DA 5 because the DA, he's trying to use a statement that he's trying to use a statement after the police put a gun in my mouth. And excuse me, I was taking my medication. After the police put a gun in my mouth and stuck his hand in my anus and called me all types of N-words and asked me where was the drugs at, and pistol whipping me, knocking me unconscious and giving me a spinal cord injury that I've been suffering for the whole time I've been in here since May 9th, 2014, where they refused to give me any medical attention, even though they put out in the media that I'm going to receive surgery, and this is why it's taking so long. Another lie. But
yeah, definitely.
What Carlos did when my lawyer filed that motion to substitute, his aim was to make the lawyer look like he didn't know what he was doing, to exalt himself over the lawyer. And I don't know why counsel just to say, listen, I've been attained to represent Mr. Guy, so therefore, know what I'm saying? That's what I intend to do. And so he had it's my constitutional right. But the bottom line is, the DA all of a sudden will say, oh, well, we have to start all over, and this and that, and this and that. It's going to take, this and that. Hold it. You wasn't saying that when my lawyer was delaying the case. It's not on me. He's been appointed to me. And I've told him to do his job, and he refused to do his job.
Yeah.
So now I've hired an attorney. I have a right, because when you look at the record as a whole, the last 2 or 3 years, he's been litigating my health, which he knows is a smoke screen, just so he don't have to litigate my case.
Right.
And so what that do is that leads me down the road and get to a point where I'm denying my due process rights because they haven't been litigated on the record. And I say again, ignorance is no excuse of the law. So I decided to educate myself. And so the only way that the judge can deny me from having hiring my own counsel is that it would be intentionally delay of the trial. We already know we have a delay because the COVID. I just had another new lawyer get on my case who is not in my best interest. So he just got on the case in July. So therefore, why can't I hire my counsel? He's not going to be up to speed. It's going to take him just as long as it would take these new lawyers who's been hired to get my case. I have more investigative power to investigate the DNA and blood, DNA, and a fingerprint that I don't have with a court-appointed attorney. But
right, absolutely.
It's strange. What's strange about it is why this lawyer, why is he wanting to stay on my case so bad? I can tell you why. He's been involved in the corrupt process, and what he wants to do instead of doing the ethical thing, which any lawyer would do when you retain counsel, he wants the judge to decide that no, you can't have new counsel. You know what I'm saying?
Right.
And so I'm sure that what he did is he asked the judge to question the lawyers or this and that. And so he was basically asking the judge for legal advice. You know what I'm saying? Instead of doing the ethical thing. And so I'm going to file a complaint against him again. And when I talk to my lawyer again, I'm telling him, listen, you should have filed a complaint against this lawyer. Because we can't come in here playing checkers and they playing chess. This lawyer has did a lot of corrupt things to me. He violated my federal civil rights. He violated, he committed fraud against me. He's built this case against me with the DA.
Yeah.
So I called him yesterday, and I asked him, listen, man, I need you to file a motion to withdraw. So I will after the judge make a decision. So you're doing an unethical, that's backwards. I have a lawyer, and the lawyer contacted you and told you, look, that they're representing me now, and you tell the lawyer to file a motion to substitute counsel so the judge can make a decision to keep you on the case.
Right.
And so that's not ethical. And I don't understand, the lawyer should have known not to do that, but he figured this is the only way they can get involved in the case, because they got it, man, where you can't, if you're not a lawyer, you can't, if you got a court-appointed lawyer, you can't, and your family hire you a lawyer, they can't come in here and talk to you. That's illegal.
Yes. Yes.
To deny a paid lawyer the right, or any lawyer the right to see you is I don't know, man. That's really wrong, bro. Because they got something going on down here, bro, under the DA office, all these attorneys, bro, that's court appointed, they're all in. And I want to have the right to meet the case against me. And if my witnesses are not showing up, if my lawyer is in the courtroom saying he's not going to call critical witnesses, like Dennis Ball, like Scott Meade, like John and you,
Right.
And these are critical witnesses in my case. And he stood in the courtroom and told Paul Williams, one of the DAs, that's supposed to be going to take the case to trial, that he's not going to call them. And I'm sitting there like, what? You know what I'm saying? And so, you know, and this guy did so much wrong to me, bro. And it's just the things that these brothers are going through down here in this courtroom under this DA, bro. It's atrocious.
Yeah, it's a travesty.
Since I've been here, I've been investigating, and I watch these guys talk about witnesses called in their case and all this. And when they go to court, they come back with 100 years life sentence. And I say, what happened to the witnesses that they never called them?
Right.
Because they use the courtroom against you. Most of these court-appointed lawyers are not going to work on your behalf. And I have a right to, I got a hired counsel now. I thank God for that, man. You know what I'm saying? And,
Yes.
You know, but my counsel shouldn't have to go through what this counsel went through. You know, I feel like he tried to exalt himself and he tried to question me, right? He said, Marvin, do you understand that I and John Dave Vaughn, whatever this other lawyer name is, I don't even know him, have been did double funding cases before. Listen, that doesn't matter. I'm not happy with your representation. You don't have to represent a double funding case before. All you have to be is a bar certified lawyer to represent a double funding case. You don't have to have no specialty. You don't have to be board certified or none of that no more. You know what I'm saying?
Right.
All you have to do is have defended a murder case in the past and you qualified. You understand what I'm saying? And
yep.
Sometimes not that. It's always the first time. But I trust these lawyers and I trust myself more than I trust somebody who's been setting me up, lying to me, setting me up, and create smoke screens to get me a life sentence. You know? And so, you know, it's tough, man, that the lawyers had to go through that. And I'm sorry that they had to go through that. But we go back on April the 5th. So the lawyer out of D.C., he has to do some kind of filing at the bar, you know. But I'm concerned that, you know, that my lawyer should have filed a complaint against that lawyer, man, you know. And I'm going to file it anyway because it's unethical for him to, you know, he wants the judge.
You have 1 minute left.
To make a ruling in his behalf. But I'm still, at the same time, I'm encouraged and I'm confident and I'm still praying, you know what I'm saying?
Right.
So, yeah.
Absolutely. It's in the Lord's hands.
Yeah. So, yeah, you know. So, that's basically, man, I want you to put that out there, man. So, that's basically